Now turn to the fourth case on this morning's docket. It is case number 104710, State of Kansas Appellee v. Eric Ochs, Appellant.
May it please the Court, Joanna Labastida of the Kansas Appellate Defender Office on behalf of Mr. Eric Ochs. I'm not actually sure how to pronounce his last name, Ochs or Ochs, the appellant. And I was not the attorney on the brief. If the Court needs my bar number, it is 24186. If I may, Your Honor, I'd like to request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. And unless the Court would prefer otherwise, I'd like to focus on Issue 1 and submit Issue 2 on the brief. Issue 1 was that the prosecutor committed misconduct when she told the jury that the truth was DT's protection. Mr. Ochs alleged that this amounted to testimony by the state regarding her testimony. It improperly bolstered DT's testimony, and it encouraged the jury to convict Mr. Ochs to protect DT. This court uses a two-part test where these comments within the wide latitude allowed the state when discussing the evidence, and do these comments constitute plain error denying the defendant of a fair trial. Basically, this court has to determine whether or not these were gross and flagrant comments, whether this misconduct showed ill will, and whether the evidence was so direct and overwhelming that the comments wouldn't have made a difference. Basically, regarding the first factor, whether or not it's gross and flagrant, in the brief, there was a long definition about what constitute gross and flagrant, and part of that was whether or not it violated long-standing rules. I could find on page 8 of the brief. It was so obviously inconsistent with what is right and proper as to appear to be flouting the law or morality. And this court and other appellate courts have many times said that the state can't comment on the credibility, it can't appeal to the jury's sense of community, that they should protect the victim. This comment it basically went to the ultimate question of the case. Was DT telling the truth, or was Mr. Ochs telling the truth? And it was a creative and philosophical thought to leave the jury with, and it was the very last thing that the jury heard from either side. And that, I think, would have even a greater impact than it being kind of buried within the 30 to 40 minute long closing of the state. This was the very last thing that they heard, and it basically told them that they needed to protect DT. The other points made in the brief, I will submit those on the brief. Unless this court has any other comments or questions, that concludes my argument. And we'd ask that this court reverse Mr. Ochs' conviction.
Your argument is that this is vouching by the prosecutor for the credibility of the victim?
Correct. That she has the truth. And if you'd like, I can read the entire statement to you, but she has the truth protecting her, and the truth is that he committed this act of rape, and that is the truth is protecting her, and that she brought that protection with her to court, which means that protection she had was the truth. I mean, she mentioned that over and over again. Protection, truth, protection, truth. And so not only is she vouching for her credibility, but she's basically instilling in the jury that it's their duty to protect the victim, who is this 11, 12-year-old girl who seemed upset during testimony based on the record that I read.
But she also in addition to the truth, had physical evidence on her blankets and sheets that tied directly to your client's DNA.
There was some argument on the defense side that could have been transferred from other times and whatnot.
What I'm getting at is, obviously, defendant has to make an argument.
Correct.
With regard to that, but what I'm getting at, this isn't solely a he said, she said, because there was physical evidence here.
That's correct.
And so why was the prosecutor's inappropriate statement so compelling, a game changer in this instance?
I would say because it did come in response to the defense's closing argument, where he went into description at length about all the different ways that physical evidence could have come into contact with the blankets. And I think maybe the state was seeing that maybe the jury could have believed that. And so really at that point, then it does become a he said, she said. And he adamantly on the stand denied any kind of or any kind of criminal conduct. And so to leave the jury with the one last thought that she is telling the truth, and that truth is protecting the victim who comes from a bad home, bad situation at home, and this is your time to protect her.
I understand that, but wasn't this the whole truth argument based on the attack that was made in closing argument to the victim? She's not credible, she's lied here, she's done this, she's done that. I mean, isn't that part of the justification for talking about her version of the truth? Right.
And that was the state's response in their brief as well, that it just came as a response to the defense's argument. I think that the state did a pretty good job addressing those arguments before this last statement. And had they not said this last, very flowery and philosophical kind of statement, then I wouldn't be standing here arguing that issue. So I think they properly addressed all of that stuff without having to encourage the jury to protect the defendant or protect the victim. I don't know if I answered your question. So that concludes my argument.
Any further questions of counsel? Thank you, counsel.
Thank you.
May it please the court, Patrick Hurley, appears on behalf of the state. In response, I'd like to simply make three comments. First of all, while the prosecutor's comment could have been more artful, it was not reversible error, as the rebuttal focused on the prosecutor in rebuttal focused on the evidence and asking the jury to evaluate the evidence, that it had to sort through a lot of the evidence, and that ultimately it was the jury that was going to have to determine who to believe. That's on page 1029, which is about 2 pages before the last comment that we're discussing here today. For my second point is, not only was the evidence presented during trial, but then during closing, as counsel had indicated, there was a discussion of the evidence by the prosecutor, and it was through this comment that the prosecutor was offering an explanation of what it should look to in assessing the credibility of the witness. And the prosecutor was pointing out that the victim's testimony was consistent with what she told the people at Camelot, which is a basis for the jury to evaluate the credibility of a witness. And then ultimately, even if this court does conclude or believe that the statement was not appropriate, it was harmless error because of the testimony by the several witnesses in the trial, the admission by the defendant to the police, and the DNA evidence that was tested confirmed that the DNA of both the defendant and the victim came from the same location, and there was the defendant's sperm on that location. And so ultimately this evidence demonstrates that the jury considered the evidence that was presented during trial, and that the statement didn't have an impact on the ultimate verdict, which was the jury convicted the defendant of rape.
Counsel, are you familiar with the case of State versus Anderson that was prosecuted by your office and prosecuted by the same prosecutor who's accused here of misconduct?
The name's not ringing a bell. What are the facts of that case?
That was the shooting outside the Granada Theater.
I am somewhat familiar.
And the same prosecutor in that case, in referring to the victim, said he's not defenseless today because he has the criminal justice system with him, and he has the truth with him. The truth will be his redemption here in the courtroom. We found that statement to be misconduct.
Okay.
I don't see any distinction between the comment made in Anderson that I just read to you and the comment made in this case. And it seems to me that this phraseology of the truth is this particular prosecutor's canned approach to dealing with juries. And if that's, and it seems like that's the case here, because it's the same kind of characterization, and we've already found it to be misconduct. So is there any way we can distinguish these statements from the ones we've already found to be misconduct in Anderson? And if so, aren't we just down to harmless error?
Well, ultimately, that's why we're here before the court, is for the court to make such determinations. You know, presumably the Anderson case was right around or right before El Nicky. I'm not entirely certain of that, as we sit here today. But I know that, it's not totally improper to use the word truth. Obviously, the context is why we're here. And I think each case, whether it's the Anderson or another case, as we are here before the court on, evaluating the context upon which that was said. And while presumably you would sit here and say, well, if she had added the word if or some other statement in that comment, perhaps maybe you would feel less concerned about it. But at the end of the day, the whole rebuttal, if you evaluate the rebuttal in context, instead of saying, well, here's what happened and here's the truth or whatever, and let me show you why or demonstrate why, it was simply done in reverse. And I would say that reverse process in this case shows that she wasn't trying to pull a fast one or do something improper. This was a case where I believe on pages 998 through 1008, there are at least 5 or 6 times where the defendant in this case called the 11-year-old victim a liar. And so you have a very emotionally charged trial, several witnesses, family members, close relationship between the defendant and the family. And so, challenging or commenting by the defense counsel on the credibility of witness is also not appropriate. And so, I would pose to the court that in this particular case, looking at what the prosecutor did during closing, asking the jury to evaluate the evidence, and that ultimately, this was simply an inartful way that the prosecutor was asking the jury on a continuous basis to evaluate the evidence. I believe on page 1029, like I said, she said, this is for you to decide who to believe. And so, in response to your question, I would say that evaluating the context provides the opportunity upon which it would not necessarily be the same. But at the same time, I appreciate the court's looking at that case and seeing that there may be some similarities.
Any further questions? Any further presentation?
No, Your Honor.
Are you also submitting issue 2 on the brief?
Yeah, we would submit issue 2 on the brief, and obviously I'd stand for questions if there were any questions about issue 2. But otherwise, I'd ask the court to affirm the defendant's conviction of rape of the 11-year-old girl.
Thank you, counsel.
Thank you.
Had reserved 3 minutes for rebuttal.
I think at this point I'm prepared to waive rebuttal unless there are other questions.
Any questions of counsel?
How old was the victim here?
How old was she? She was 11, I think. I think she was 12 by the time she testified at trial.
Any further questions? I see none. Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement. That concludes the morning docket. Court is in recess until 9 o'clock tomorrow morning.